finally. All right, so members, we're on file item 5, Assembly Bill 392 by Speaker Atkins regarding the San Diego River Conservancy. Please begin.
Thank you, Madam Chair and Senators. It's my pleasure to also present today Assembly Bill 392, which would enable the San Diego River Conservancy to take its place as one of our state's permanent conservancies. The San Diego River Conservancy was originally created in 2002 with a 2010 sunset date. And while the sunset date has been extended once to January 1st, 2020, over the past 13 years, the Conservancy has established its value in the region. With 700,000 people living within the area of influence and an additional 2 million people in adjacent communities, the Conservancy has successfully implemented $20 million in state funds while leveraging millions more in federal, local, and private funds. In its 12-year history, the Conservancy has overseen over 100 acres of restoration along the river, the construction and or renovation of approximately 15 miles of a public trail along the river that is well used by people of all ages, and in the acquisition of over 200 acres of land from willing sellers. Proposition 1 passed by voters last November includes $17 million for projects in the River Conservancy's watershed, with projects estimated to take 5 to 10 years to complete. Grantees must be monitored for compliance with grant conditions on capital projects for up to 25 years. Future expenditures funded by the Conservancy using Proposition 1 and other leveraged funding sources will include projects that improve water quality, enhance water supply, manage flood control, and the protection and management of wetlands and watershed areas. The Conservancy has a history of clean audits with successful track record of both receiving and administering grants and contracts for projects within the watershed. Finally, 8 of the 10 existing state conservancies in California are permanent agencies. We think the time has come for the San Diego River Conservancy to join with its fellow conservancies as a permanent agency of the state. I have several speakers with me today, Madam Chair.
Very good, and I know I noticed there's no formal opposition to the bill. Chair will be supporting this measure, so
duly noted.
Perhaps the hint would be to not oversell.
Got it. Jonathan Clay on behalf of the County of San Diego in support. I'm also here today representing Ben Clay, who's the chair of the San Diego River Conservancy, who apologizes for not being here today, but he let his Italy trip get in the way of important testimony. So as the speaker detailed, as also was detailed in analysis, the San Diego River Conservancy had a number of successes as they look to continue to partner with their cities, other public agencies in the region, having the ability to go beyond 2020 in terms of their life of the agency is helpful in those partnerships for them to continue to do the good work. And with the provisions built in terms of reporting requirements, I think that those adequately cover oversight and in transparency so people understand what work the Conservancy is doing. With that, I will stop and be available for questions.
Thank you, and I will also note that it had unanimous support in the State Assembly as well, just to point that out. Next.
Madam Chair, Moira Top here on behalf of San Diego Mayor Kevin Faulkner and the entire City Council. We are in support of the measure. The Conservancy has been a tremendous partner with the city, and we support its making it permanent. Thank you very much.
Thank you. Any opposition to this measure? Anyone like to add on with their name? Let's hear from proponents first. Your name, affiliation, and position of support.
Elizabeth Burns, Sierra Club, California, and we support the bill. Thank you.
Thank you. Any other supporters?
Claire Desser on behalf of CalTrout in support.
Charles Watson on behalf of the Urban Core of San Diego County in support. Thank you.
Nice.
Juan Altamirano on behalf of Audubon, California in support.
Anyone else wishing to add on in support? How about opposition to this measure that passed unanimously out of the Assembly? Okay, seeing and hearing none, this looks pretty good. Questions by members? It's been moved by Senator Allen. No questions, comments? Close?
I would respectfully ask for your aye vote.
Thank you very much. And 2020 isn't far away, and I appreciate you need that lead time for people to know that this Conservancy will be around for generations to come. Thank you for your good work. And Senator Kehoe's work.
Kehoe, absolutely.
Yeah. Roll call vote, and the motion is due pass to appropriations.
Senators Pavley.
Aye.
Pavley, aye. Stone. Allen. Allen, aye. Hertzberg. Hueso. Jackson. Jackson, aye. Monning. Monning, aye. Vidak. Vidak, aye. Wolk. It has 5.
You have 5 votes, and we'll leave it open for other members to add on. Thank you very much for your presentation on both items. Assemblymember Alejo, you have 2 items, correct? And file item 4 will be the first one. Thank you for your patience. You sat through elephants, rhinoceroses, and San Diego Conservancy.
Important issue.
Okay. This is file item 4, members, Assembly Bill 300 by Assemblymember Alejo, and it's been dual referred to environmental quality, which many of us are also on. And so go ahead and begin.
Thank you very much, Madam Chair and members. This bill came about because of the water quality problems we have seen at Pinot Lake, a small lake in my hometown of Watsonville. When we began talking about the problems at Pinot Lake, we learned that the toxic algae blooms are increasingly causing toxic and poisoning events in coastal lakes, estuaries, and rivers all across California. The toxic algae threatens water supplies, human health, and animal health, and it's a special problem for people fishing in this lake and taking fish home for their families to eat. I would like to accept the committee's staff's recommendations for clarifying amendments, but this bill is quite simple. It calls for developing a statewide strategy for reducing algae and then ties the strategy to funding sources that the various agencies like Fish and Wildlife, the Coastal Conservancy, and the State Water Board already have. The bill is supported by the City of Watsonville, and I'm pleased to have the support of the city, the Defenders of Wildlife, Save Our Shores, and the Korut tribe who are dealing with this problem on the Klamath River. Here to answer any technical questions is Robert Ketley from the City of Watsonville. I respectfully ask for your aye vote. Thank you, Madam Chair.
And thank you for your presentation. Is this the speaker in support? Okay, very good. Thank you. Welcome.
Yeah, Members of the Committee, thank you. City of Watsonville, Robert Ketley. Been dealing with these for 10 years. I won't belabor the point. If you have any questions, technical questions, I'd be happy to answer them.
Very good. My husband's family is about 80-year residents of Watsonville.
Right. Oh, great.
Thank you, Madam Chair. I want to thank my friend and colleague, Assemblymember Alejo, for bringing this forward, and the City of Watsonville for its work on this. The Pinto Lake issue and the algae bloom there that the Assemblymember made reference to, that's also in my Senate district, and some of what we've learned is some of the potential impacts to sea otters in the Monterey Bay are being traced to land-borne contaminants and potentially the algae blooms. So we learn more and more of the interconnectivity of our ecosystems. So I just want to thank Assemblymember Alejo for bringing this forward, and would be glad to move the bill at the appropriate time.
All right, thank you very much. Any opposition to the bill? Or support for the bill? Anyone here in the audience? And any other comments or questions by members? Up, go ahead. Do you want to, did you need her to do that again? He's just taking, so we have it on record.
Elizabeth Burns, Sierra Club, California, in support.
There we go. Thank you. All right, there is a motion by Senator Monning, and I'll just note for the record that coastal areas, maybe it's the warmer ocean temperatures, a variety of other factors affecting marine mammals, and of course the sea otter. It's perhaps one of those characteristics of a warmer climate that's causing all this in addition to it. So thank you for bringing this to our attention, and costs associated with this will be addressed in appropriations as far as the creation of the task force, et cetera. If you would like to close, Assemblymember Alejo.
Very quickly, Madam Chair, I want to thank you for support and for Senator Monning for co-authoring this bill. This lake in Watson is a special place, but as Senator Monning pointed out, a National Geographic magazine covered it because of its link to the deaths of marine life, including sea otters in the beautiful Monterey Bay area. But this is a project where for cutting-edge research, and the City of Watsonville and other stakeholders have come together to try to learn from the work that is being done there to also address this very same toxic problem in other parts of the state. I respectfully ask for an aye vote, Madam Chair.
Thank you. Roll call, please. And the motion is do pass as amended to environmental quality.
Senators Pavley.
Aye.
Pavley, aye. Stone. Allen. Hertzberg. Hertzberg, aye. Hueso. Jackson. Jackson, aye. Monning. Monning, aye. Vidak. Vidak, aye. Volk.
Let's go back and reopen the roll.
Senator Stone. Allen. Allen, aye. Hueso. Volk.
All right. You have enough, that motion, that measure is passed, but we'll leave it open for absent members. Let us go on to your second bill, Assemblymember Alejo. That's Assembly Bill 1390. Members, that's way down on file item 18. Thank you, 18. File item 18 on groundwater adjudication. And I would note for the record, both Assemblymember Alejo and myself have legislation on this issue. They're not conflicting. They're different approaches to address it. And so there's no conflict in allowing this bill to move forward. Go ahead and present.
Thank you for that, Madam Chair. Today, we're here to present this bill, AB 1390, a bipartisan bill that will bring new efficiency to the process of adjudicating water rights in groundwater basins. When the governor signed the Sustainable Groundwater Management Act, or SGMA, authored in part by Madam Chair, there was an interest in streamlining the adjudication process. This bill will work in conjunction with SGMA just to do that. For this reason, this bill has attracted 20 co-authors from both parties and both houses in the legislature, including members of this committee. The goal of AB 1390 is to clarify court procedures that apply to comprehensive groundwater adjudications to reduce the time and improve the efficiency of the process, thus reducing cost. Specific provisions of this bill will encourage early settlement and avoid undue disruption of local groundwater planning. And much of California management of groundwater resources will be made easier by the identification and quantification of local groundwater rights, the purpose of an adjudication. But that process, as we all know, is longer and less efficient than it should be. And making groundwater adjudication more efficient will relieve the burden on the courts, and at the same time, it clarifies groundwater rights, bringing a double benefit to the entire process. While this bill will make the process quicker and easier, we are under no illusion that adjudications can be made short and easier. However, this bill will certainly make the process more efficient while protecting due process rights for all involved. This bill received unanimous bipartisan support in the Assembly Natural Resources, Assembly Judiciary Committee, and the Assembly Appropriations, and on the Assembly floor. We are currently in the process of working with the opposition, the administration, and the Judicial Council to work out technical issues and concerns as this bill moves to the Senate Judiciary Committee, hopefully after today. I respectfully ask for your aye vote, and with me here today are some folks to speak in support of this bill.
All right. Speakers in support.
Thank you, Madam Chair, members of the committee. Jack Rice with the California Farm Bureau Federation. And we were just building on last year, the discussion, part of which came out of the hearing held by this committee about the need to improve the efficiency and operation of groundwater adjudications. And so what this bill is focused on making procedural improvements to that process, and it fulfills the intent and promises we understand it of SGMA, where leaving the substance of groundwater law the same, but making the procedural improvements to make them less wasteful. Really quickly, it's got a preliminary hearing component that is in a way of ensuring that the groundwater adjudication, a comprehensive adjudication of rights, is the appropriate approach. There's changes to the service of process to allow for mailing through the tax bill and also publication in order to satisfy due process and also provide practically so everybody that needs to know is aware. Basin boundaries, this is excuse me, one of the places where we've tried to make sure this fits with SGMA. Basin boundaries are presumed to be the Bulletin 118 boundaries that are part of SGMA, so we're trying to make sure that process is relied upon. In addition, the case management, some of the time sinks that were identified, it's going to be presumed complex, so it goes to a complex litigation department. There's limiting the number of peremptory challenges. break it into phasing, use a special master. There's a number of procedural details that will help improve the process and functioning. A lot of those come from what we've learned in other adjudications that have already occurred, but by putting them in statute, you have the rule book sort of laid out in front of you. And then finally, settlement. There are specific provisions that allow and encourage settlement, and it also is a means of integrating it and coordinating it with the Sustainable Groundwater Management Act, in that the groundwater sustainability plan can be the basis of a stipulated judgment. There are also provisions related specifically to how a stipulated judgment, the percentage, and I know there's been some concerns over that 50-75% issue. That was intended to kind of capture the City of Barstow versus Mojave decision, and so if those numbers are not correct, the concept was just to capture what happened in what the Supreme Court identified in the Mojave case. And so with that, I'll let Lauren speak and answer any questions.
Second witness, please.
Good morning, and thank you, Madam Chair and members of the committee. Lauren Hajic on behalf of California Fresh Fruit Association, California Citrus Mutual, Western Plant Health Association, Western Ag Processors Association, California Tomato Growers Association, as well as other agricultural commissions and associations in strong support of this bill. As has been stated, this bill really focuses on the procedure of adjudication actions and comprehensive adjudication actions. What this does is identify those time sinks so that groundwater rights holders of all sizes, whether they be large landowners or small landowners, water agencies, et cetera, can actively engage in the comprehensive adjudication action and not be subject to the time delays that exist in the current adjudication proceedings under current law. As stated, there's a preliminary hearing process where when a plaintiff files a comprehensive adjudication action, they must go to court and show that a comprehensive adjudication of the entire basin is needed. The court can look at that evidence and decide, yes, the entire basin needs to be tipped into this adjudication action, or no, it's a smaller, more limited quiet title action, or a smaller well interference action that does not need to drag in all users into an adjudication action. This should ease the burden on smaller landowners who may have been dragged into adjudication actions before that were later dismissed, lowering the costs of those actions to smaller landowners. Also, since it's focused on procedural issues, it doesn't touch the substance of groundwater law or groundwater policy. This is important for those basins that are under the Sustainable Groundwater Management Act. By just focusing on procedure, this does not delay or hinder those agencies who are under the SGMA basins. They can still continue, they still must meet those timelines, and the court can actually stay a proceeding if a groundwater sustainability agency is moving forward in a productive manner that will sustainably manage the basin. But the court also has that check to make sure that groundwater rights are being honored and smaller landowners or other landowners, their rights are not being infringed upon by any other action. Further, I'd just like to note that this law, since it is procedural, that aim was to make sure that it applied to all basins in California so that this law could be used in those basins under the Sustainable Groundwater Management Act and also those basins who are outside of the Sustainable Groundwater Management Act in an efficient way that cuts back on waste. And with that, I respectfully ask for your aye vote.
Thank you. Now we'll be hearing from others in support, excuse me, name and affiliation.
Dennis Albiani on behalf of California Grain and Feed Association, California Seed, Almond Holders and Processors Association, and a list of others, agricultural associations in support.
Thank you, Dennis.
Good morning, Tricia Garinger, Agricultural Council of California, representing over 15,000 farmers throughout the state, also in support.
Thank you.
Valerie Nera for the California Chamber of Commerce, also in support. Margaret Gladstein on behalf of Western Growers Association in support.
Thank you, Margaret. Anyone else in support of this measure? Opposition. There is opposition to this measure, as you can see from the analysis.
Good morning, Chair, members of the committee. Kyle Jones with Sierra Club California in opposition. Our biggest concern with this bill is the requirements for a stipulated judgment, where a court has to accept a stipulated judgment by parties where there's only 50% of the parties agreeing and 75% of the water producers. Our biggest concern with that is that people can lose rights by means of prescription without being represented, and the court has to accept it. It's mandatory. There is a way for other parties to get around this, but it's a difficult burden for them to show. And then we're also concerned about the 75% number of produced water in the past 10 years at a time like now where people are running out of access to water through their wells, and that the people who are able to produce water the most effectively are those who can, or only those who can afford it. We think this has issues with disadvantaged communities. We understand that this is based on the Mojave case, but we don't see why it needs to be codified in this way. The court already has the discretion to do this as they've done previously in the past, and for those reasons we're in opposition. Thank you.
Thank you.
Good morning, Madam Chair. Karen Keene on behalf of the California State Association of Counties. We have an oppose unless amended position on the bill. Our concerns are not focused on the environmental, natural resource related issues, but more on the procedural aspects, specifically the one requirement that would make counties automatic parties to the actions. We have a number of other issues, procedural issues with the bill that are outlined in our letter. We have had several meetings with the author's staff and the sponsors. We've appreciated the dialogue so far, and we want to continue the dialogue and hope to have our remaining concerns addressed before the Senate Judiciary Committee hearing. Thank you.
Thank you.
Members of the committee, Kathy Mannion, representing RCRC 34 rural counties. We're also on the joint oppose unless amended letter. I did want to mention one specific item in particular that is of great concern to counties, and that is the due process involved in sending a notice of the adjudication in the property tax bills. We do see this as being a considerable problem, as so often people have impound accounts. We may have a lag in the change of ownership and other related issues where a notice is sent back. So we do see that as being an issue. Our involvement in sending out these notices, as well as the cost and liability, is a big issue. If this were to stay in the bill as it is, requiring the county to send these notices, then we would need to have a liability protection stated in the bill as well. Thank you.
Kelly Diddon on behalf of California League of Conservation Voters, oppose unless amended for the reasons stated previously.
Thanks.
Debbie Orrs on behalf of Community Water Center and Clean Water Action, also oppose unless amended.
All right. Thank you for that. Oh, I had one or two comments, and I'll open it up for questions. I had mentioned, or it had been mentioned, that we had a hearing last November. It was very instructive. No matter where you were in the discussion of the bills that establish the Groundwater Sustainability Management Act, everyone agreed that the adjudication process was unnecessarily long, complicated. We still have one going out in the Antelope Valley. I think it's 15 years and counting, with no end in sight. No offense to the attorneys, but the people who are doing really well in this are the lawyers. We've had it's. I can't resist. So the adjudicated basins are not involved in this Groundwater Sustainability Management Act, and my hope is that more people will embrace and develop the agencies and the plans to comply with the act and avoid the adjudication. It is really long, and so we're starting to make a lot of headway. I've met with DWR in regards to their efforts in providing the technical assistance and getting people off and running, so that's a good thing. I was going to note for the record, Senator Jackson, this is double referred to your committee. There were a couple of issues that you can address better than I when it comes to your committee. It was raised, I think, by the Sierra Club on stipulated judgment. And also, there's a difference in, Assemblymember Leo has a code of civil procedures where they put this chapter in, and I had it inside the Groundwater Management Act itself. And so that's something you can address. I guess it relates to level of due process. It's in your jurisdiction, not subject for today's discussion. All right? So questions of members?
Yeah, you hit exactly the 2 points I was interested in, civil code and also this adjudication process. And I would ask the opponents to be prepared because I serve with Senator Jackson on her committee and Senator Monning. And I think it's pretty important because the assumption about that is, I mean, there's a balance here. I think Senator Pavley just articulated it. And that is, if you have an adjudication process of 15 years, what are you trying to accomplish? What's the deliverable you're trying to accomplish? And is the delay so great? And the assumption that the delay is adversely affecting people of less means, maybe that's not the case. Maybe there's a recalcitrant party, and then we balance that against the environmental interests. I mean, I just think be prepared to answer those questions because we're going to really drill into that question for you in the next committee. And I just, because, I see the Sierra Club and these other groups that are important that are against it, but I'm not so sure. And then secondarily, the last point I just want to make is that let's look at this jurisprudentially with respect to other areas of the law. There's a number of other areas where we expedite proceeding, where we balance public interests. We do it in all sorts of areas of the law, domestic violence cases. I know it's not the subject of this, but I think it's really important to be prepared to answer those questions and think about it because, that seems to me a critical element with respect to the legitimacy of your opposition.
Yes, we were working on, and what I took away from last fall were some of the ones that were the easiest ones to implement, and a lot of it was looking at the federal government as a better model regarding notifications. The representative from RCRC brought up something that I wasn't aware of. That's notice in property taxes and potential problems with the county doing that. That was something new to me. But we also had in the bill that I was authoring, everyone debating what the boundaries are. So we were using the Bulletin 118 boundaries, and that would help facilitate that discussion. The notification process is just needless delay and sharing testimony and information back and forth and hiding it, if you will, until you get to the hearing. It's not the way we operate in other areas of the law. So yes. Senator Jackson, you had
Thank you. And as you note, should this bill pass today, it will come to the Judiciary Committee. Delay, I think we all agree that the delay is absolutely unacceptable. As I have made this commitment, I've got a bill on CEQA process to try to streamline it as well, but at the same time maintain its integrity. And I appreciate Senator Hertzberg pointing out that there is a balance, and we will certainly be addressing it. I'm told that there are at least 2 or 3 pages that we're going to be addressing that just talk about service of process, what that takes. I mean, obviously, this has been laden down with all sorts of requirements that we need to kind of cull through and get to something that's more efficient and expeditious for everybody. 15 years is just not...
And counting, it's not over.
Yeah, and to give lawyers a little bit of a break on this, lawyers wouldn't continue a case unless they have clients who are committed to doing so. So I know we like to blame lawyers for everything, but you have to have clients behind you. I don't even know who they are, but these things don't continue without the litigants wanting to continue it. So we'll try to address that. I did want to make one point, though, that as we look at the distinctions between the 2 bills, I know Senator Pavley has one in the Sustainable Groundwater Management Act that was just passed last year. This one is in the CCP, and as Justice Roby pointed out at our hearing, the groundwater adjudication process is not designed to consider the environmental aspects and has no role for public interest groups or anyone else to participate. And I think those are distinctions that we also have to recognize that might be more relevant in this committee as we then will move this forward. So I will support this bill to move forward to the Judiciary Committee with no promises. It will depend excuse me, if we can address some of the issues that have already been raised today. And I do, again, want to reiterate what Senator Hertzberg mentioned, is that the key question here is how are we going to be able to balance the key interests from a critical procedural aspect, which will be coming to the Committee to Judiciary. So I want to thank you. Courageous effort here. This is really a complicated, unnecessarily complicated measure, which we'll try to expedite, but again, making sure that we consider all the interests that are represented in that measure as well.
Thank you for those comments. And the only other, in your close, Assemblymember Alejo, comment was from the Sierra Club. Maybe you can mention your close on whether, regarding disadvantaged communities, the part of 75% of water production for the past 10 years will adversely affect smaller landowners and leave them without a voice in a settlement, whether that statement is something you'd like to address in your close. That was one of the other comments from the opposition that might need to be addressed. This bill, as I said, one reason it's not directly in conflict with mine, because some of the elements are the same, and it's both about expediting, and it's within the framework of support, not diminishing the work done by putting together the Groundwater Management Sustainability Act, or diminishing that in a way. It's simply focusing on streamlining adjudication. Assemblymember Alejo.
Thank you, Madam Chair. Just to answer the one specific question, I'll have our expert witness just answer that, and then I'll do my close quick.
Thank you. We were also very concerned about small landowners. You probably know that a lot of Farm Bureau members are small landowners, and they're not all large landowners. And so the ways that we tried to address that were some of those longer provisions, the form notice, the form answer. Those were intended as means to allow individual landowners to be able to participate meaningfully in the process without having to be able to invest the resources to hire their own attorney to represent them independently that you might expect a water district or a larger landowner. And then in the settlement processes, or I should say another aspect of the bill, is also the ability of the court to use classes. And one of those is what we've seen as a small landowner class, where small landowner classes are dealt with as a whole, and that's how they're able to be appropriately part of the process and find an appropriate solution. So we've tried very hard to address that procedurally.
And to close, I just want to say we look forward to working with the Judiciary Committee to address some of those issues as well. But we've got a lot of input so far from a lot of stakeholders trying to address a lot of the concerns, including those concerns coming from the governor's office. But as we all know, when the governor cited SGMA last year, this was one issue that he recognized in his message that it needed to be addressed: expedited water adjudication, for all the reasons already stated. And I think what our bill reflects is some of the lessons learned from those cases that have gone on for such a long time, and really trying to find more efficient way to address these issues and find consensus building and agreement, but still protecting people's due process rights for those that do not agree and still have concerns or claims that they want to pursue in court. Just to address the Code of Civil Procedure issue, that was largely because our approach is that this bill is purely procedural. It's not substantive, doesn't change anything from SGMA, actually runs parallel to it. And the existing adjudication process in court is also laid out in the Code of Civil Procedure, and that's kind of why we structured our bill in that fashion. But nonetheless, we look forward to keep working on this bill and addressing the concerns as it moves forward. And with that, I respectfully ask for an aye vote, Madam Chair.
All right. Is there a motion on the bill? Senator Monning has moved the bill, and it's due pass to Judiciary. Roll call, please.
Senators Pavley.
Aye.
Pavley, aye. Stone. Allen. Hertzberg. Hertzberg, aye. Hueso. Jackson. Jackson, aye. Monning. Monning, aye. Vidak. Vidak, aye. Welk. Welk, aye.
Thank you very much, members.
Thank you. We'll leave that item open. File item 7 was continued, so we're on to file item 8. I note the presence of Assemblymember Levine. It's AB 549. It's on state parks. And there's no formal opposition to this measure. And there are amendments on pages 4 and 5, which the author is accepting.
I am accepting them, and I
And
respectfully
thank
ask
you
for
very
my
much
vote.
for working on this. These all came from the Parks Forward Commission recommendations, and some Assembly member and myself are both working on trying to assist them. Sometimes it takes changes in statute to implement some of these reforms. So thank you very much for your work on this.